Let's talk about trusts, specifically the role of trusts in multi-generational wealth protection and transfer. So there's a lot of information out there today about the different types of trusts, the different uses for trust, and frankly, there's a lot of misinformation as well. So today we'll review the different types and what you should be using them for. The most basic and common type of trust is the revocable living trust. So this type of trust is set up while you're alive. It gives you full access to and control of the assets owned by that trust, and it's really flexible so that you can update it throughout your life. This type of trust does not offer any kind of asset or tax protection, but it does help you avoid probate after you die. Think of this trust as a written instruction manual on what to do with your money or your estate after you pass away. Everybody should have a revocable living trust, regardless of your net worth, regardless of how much money you make. Everybody should have this because sending your family through probate to handle your estate is never the best option. So after you set up your revocable trust, one of the biggest mistakes that we see is that so many people forget to fund their trust. A trust simply is just a document, right? It's just a document that outlines what you want to happen. Unless assets are properly titled in the name of the trust or list the trust as a beneficiary, the trust literally means nothing. So you have this $10,000 trust that you set up, and it's got all the bells and whistles and everything's in it, but you never went to the step of maybe deeding your house to the trust or titling your investment accounts in the name of the trust or adding your trust as a beneficiary. All of those assets are going to go to probate. Even though you have this trust, the trust doesn't technically own those assets. So this is a super crucial step that so many people forget. And if you're working with a family office or financial advisor, they need to make sure that they're working with the estate planning attorney to make sure all of your investment accounts are titled correctly, your house deeds or your real estate deeds are changed. That way your trust is fully funded and is effective. Let's talk about irrevocable trusts. Irrevocable trusts should be considered as permanent. They remove assets from your estate, and a lot of times you lose control or access of some of those assets as well. But what you gain is protection against lawsuits and creditors, and there are some estate tax benefits as well. These types of trusts are pretty permanent, so they can't really be changed after you set them up. So you want to be deliberate when you make decisions about who your trustees are, who the beneficiaries are, and which assets are going into these types of trusts. These types of trusts are a powerful planning tool for estate tax. So they help you remove a highly appreciating asset like a business or real estate or investments from your taxable estate so that they won't be subject to the estate tax of 40% after you die. Another type of trust is called the charitable trust. There are charitable remainder trusts, charitable lead trusts. There's a lot of different kinds out there, but really this helps you accomplish your charitable goals by use of trusts and removing assets from your taxable estate. So your family can get tax benefits today by using these types of trusts, and you can still have control over what happens to the assets and where that money is given. So if you're charitably inclined, a charitable trust is definitely something you should look at. There's a unique trust out there called the SLAT. This trust is used where one spouse gifts assets to the trust for the benefit of the other spouse. That gift uses part of their lifetime exemption, but that money is still accessible by the other spouse to use throughout their lifetime. So this is an estate tax strategy to help lower your taxable estate and push out some highly appreciating assets from your estate while both spouses are alive. That way you're using the current high exemption amount that's given today. One of the most important functions or parts of setting up a trust, regardless of the type of trust, is who you select as a trustee. This needs to be someone who is trustworthy, who's going to carry out your wishes, and who's going to be a true fiduciary and steward the assets to your wishes. This can be a family member. It could be a friend. It should be somebody that's going to live long enough to execute on the trust. You can have successor trustees or backup trustees in place, but you want to choose someone that you've had a conversation with, that understands your wishes, and that are trustworthy enough to make sure that your wishes are carried out. It's always great to have a co-trustee as well. So maybe you designate a trust and a co-trustee. That way you have two people working together, talking, communicating, kind of bringing some accountability into the picture to make sure that your true wishes are carried out. Maybe you don't have somebody in your family that you trust, or maybe not somebody that you would want making those decisions. You can always hire a professional trustee. There are companies out there that are held to a fiduciary standard that will uphold exactly what the trust says, and it's a completely unbiased third party. Now, obviously there are costs to that, but it's definitely an option. One of the questions we get a lot is, can one of my kids be a trustee of the trust? And the answer is yes, they can, right? Absolutely, they can be a trustee. I would say if they're mature enough and you truly trust them to make good decisions, a lot of times interests get mixed when a trustee is also a beneficiary. When you blend control and benefit, it can create some conflict of interest that may not be great. So I would consider having in-depth conversations with your kids, making sure they're all on the same page, making sure they understand why maybe the oldest son or daughter is the trustee, or maybe appoint them as co-trustees so that they have to work together. Having a third-party trustee is often the best route because you have an unbiased party who's only going to operate on your wishes. They don't have any interest in the assets or as a beneficiary at all. How often should you review or update it? We get this question a lot. You want to update or review your trust every 3 to 5 years. Now, this should be on your family office or your financial advisor's plate. They should be the ones prompting these reviews. But also, if there's any kind of major life event that happens, maybe you have another kid, or maybe your children get married and they start having kids. Maybe you sell a company or you purchased or sold some large real estate assets. Those types of life events should always trigger at least an analysis of what you've got going on in your trust. It doesn't always mean that you have to throw it out and restate it or amend it, but at least look at it to make sure that the wishes that you had before the life change are still the same. And if they've changed, you need to update it. Trust and estate planning are always complex topics. You should have a family office or financial advisor that understands these topics. And you should be working with an estate planning attorney that they recommend or maybe that you have. And those two should be talking. Your financial advisor, your family office should be coordinating with your estate planning attorney. It's not on you to make and know all of these decisions, but it's super important that your financial advisor is talking to your estate planning attorney to make sure that you've got the best estate plan for you and your family.